again, the easiest thing to say is just to say good day. Now, it's my profound honor to welcome you to today's webinar. Of course, I'm Omar Hosseini, the Secretary General of the OIC Arbitration Center, and I formally welcome you to today's webinar titled Silicon Gavel, Ethical and Responsible Use of Artificial Intelligence, AI, in Arbitration Practice. Now, today marks a significant milestone for all of us. Just last month in the historic city of Paris, the OIC Arbitration Center and Jus Mundi signed a landmark memorandum of understanding. And that agreement was not merely a formal handshake. No, it was a commitment to, bridging the gap, between institutional wisdom and the frontier of digital innovation. Today's session is the very first initiative born of that partnership, and I cannot think of a more vital or timely topic to inaugurate our collaboration with Jus Mundi. So we have spent years discussing artificial intelligence as a future prospect or a looming disruption. Today, we must speak with more urgency and clarity. AI is no longer a future question for arbitration. It is already shaping decisions, strategies, and outcomes. And you're going to hear a lot today from our distinguished panelists. As we stand at this crossroads, we are forced to grapple with questions that will define our profession for decades to come. Now, one of the questions actually relates to the line of authority. Where exactly do we draw the line between AI as an assistant and an AI as a decision maker? Now, one other question we may want to also discuss is the pillar of justice. In an environment increasingly driven by algorithms, how do we safeguard the absolute non-negotiables such as impartiality, due process, and fairness? And one other thing is, of course, the legitimacy crisis. Is AI truly a tool for unmatched efficiency, or does its black box in quotes nature pose a risk to the very legitimacy of the arbitral award? Of course, we can talk about the New York Convention. How do you enforce this, when there's AI involvement? This is something, again, you can ask today. You've got a distinguished panel. Now, from the complexities of predictive justice and its impact on third-party funding to the evolving ethical boundaries in investor-state arbitration, we are here to challenge assumptions. We aren't just looking for use cases. We are looking for a roadmap for responsible practice. Now, ladies and gentlemen, before we dive into our expert panel, I must share a crucial development regarding our institutional framework. On April 16, 2026, and that's about, I'll say maybe 10 days ago or so, the presidency of the Republic of Turkey issued a momentous presidential circular specifically regarding the OIC Arbitration Center. And for those of you looking to file cases or advise clients on dispute resolution in this region, I think it's important for me to share a quick summary of the presidential circular. The circular formally recognizes and elevates the OIC Arbitration Center as a premier global hub for international commercial and investment disputes. And it also mandates all public institutions and organizations to utilize the center's services and ensure that the process of filing and managing cases is more efficient and legally robust than ever before. And this is the first time this is happening here in Turkey. And it serves as a green light for the international community, signaling that Istanbul is not just a bridge between continents, but a fortified sanctuary for neutral expert dispute resolution. So if you're considering the OIC Arbitration Center for your next filing, this circular provides the procedural certainty you need to move forward with confidence. And of course, from the ISDS perspective, in 2024, the government of Turkey has also made it a policy that all BITs, that is bilateral investment treaties, must contain the name of the OIC Arbitration Center. Now, let me conclude. I want to extend my deepest gratitude to our partners at Jus Mundi. By combining our institutional insight with your cutting-edge legal intelligence, we are ensuring that the OIC member states and the wider global legal community remain in or remain at the forefront of the digital revolution. To our panelists, thank you for being here with us today. You are the architects of this, what I think Mariam calls Silicon Gavel. We are eager to learn from your professional guidance as you help us navigate this uncharted territory. And finally, to our participants, this is not just another webinar. It is a live conversation about the survival and evolution of our craft as arbitrators or practitioners. I encourage you to be bold in your questions and critical in your thinking. Without further ado, let us begin. Thank you very much. I now hand over to Ziad, who will moderate the session. Thank you.
Thank you very much, Dr. Umar, for this wonderful introduction. And let me reiterate our genuine pleasure at Yusmundi for signing this MOU with UIC. And this is just the first step in what I'm sure will be a wonderful collaboration going ahead. Let me also extend my deepest gratitude to our esteemed speakers for accepting our invitation to join us for this panel today. So before getting into the topic, let me first introduce our esteemed speakers. So first we have with us Mariam Al-Rashid, who is a global international public and private alternative dispute resolution arbitrator and business and human rights advisory. For over 23 years, Miriam has championed the intersection of law, human rights, and storytelling. Her work spans international arbitration tribunals, United Nations forums, and award-winning film productions, all united by a singular mission of advancing justice on a global stage. Miriam has represented sovereign states, multinational corporations, and global investors in complex disputes spanning the MENA region, Central Asia, Europe, North America, and Latin America. We have also with us today Professor Joshua Carton, who is an independent arbitrator and professor of law at Queen's University. Joshua teaches and writes about commercial dispute resolution, international comparative contract law, international economic law, transnational legal theory, globalization and law, and also linguistic issues in law. Aside from his scholarly activities, Joshua practices as an independent arbitrator and legal consultant. Last but not least, we have with us Riham Ragab, who is founding principal of Ragab Law. Riham is an Egyptian attorney with over 20 years of experience. She provides both operational and strategic legal advice to her clients. She sits as arbitrator and mediator and has legal expertise in, amongst others, international arbitration, corporate law, international transaction, complex contracts, and commercial negotiations. Before founding Ragab Law, she held legal positions in law firms and executive directorship in-house positions as group general counsel of two conglomerates in Egypt. And I'm Ziad Abou Leil. I'm Senior Global Relations Officer at Yusmundi, and I'm also a PhD candidate and teaching assistant at University Paris-Saclay. So for all our dear guests, you have the Q&A option in the chat. Whenever you have any questions, we invite you to send them over through the Q&A, and we'll make sure to get to them through the panel. So without further ado, let us get ahead with our first topic of the day, which is the very controversial discussion around AI as a decision maker itself. So Miriam, I'll start with you. So we hear a lot of enthusiasm about AI as a decision maker, but at the same time, there is a lot of concerns. What are the real implications of having AI decide a dispute? And what do you think is the most misunderstood about this debate?
Thank you very much I keep getting pop-ups. Thank you, Ziad, for the question, and thank you, Umar, for having me and everyone on the panel joining you. It's a pleasure. So that's a rather broad question, and I have to, I guess, start with the main concern. Well, if I could ask Ziad, what is the primary question here? Because that's multi-layered.
For you, in your opinion, what is the implications of having AI decide a dispute? So this is the main issue in it. Yeah.
Okay, so the key point for me is I'll answer it like this: AI should not decide disputes. Period. What AI should do is facilitate effective work product to move forward into aspects of the process in a dispute resolution proceeding, to make it efficient, effective, responsible, of course, with oversight, human oversight. Ethical and responsible oversight is required for the use of AI to be efficient and effective in the arbitral process towards a legitimate, just, accurate decision by a tribunal that can be enforceable according to the New York Convention, according to the Washington Convention, according to any jurisdiction that is that would be that has signed on to those conventions where they enforce foreign arbitral awards. So AI should not in any way make a decision. And I should say something very important here on the point, because it ties to what you will bring up, which is predictive analyses of decisions, and if we could use AI to make predictive decisions or outcomes. And I'm wholly against that. I think that, again, it should be used for predictive purposes on particular aspects of a case, like damages. But that's what experts do, right? They come and they predict the damages in various formats and process of analyses, the way that they decide, how do they decide the damages, which model do they use, discounted cash flow, future, market rate, and so forth. So I'm wholly against that. And it's really a question. I have a lot more to say about this, but I have to stop. It's important to know that our artificial intelligence in dispute resolution, alternative or in court, must answer to the bar, not the institutions, not the arbitrators, not the arbitral tribunals, meaning that while the promise of artificial intelligence in international arbitration is real, that does not mean it is definitive, nor should it be used as a definitive tool like decision. And it's good at faster drafting, smarter document review, things of that nature, promises, but these promises come with peril. And institutions manage cases, arbitral institutions manage cases, but the bar licensees, i.e. we, the people, the attorneys, are the ones that safeguard justice. We're bound to the bar. And so the AI needs to do the latter. It also needs to answer to that, the latter, the bar, not institutions that decide whether it's going to be predictive and how AI will be used and so forth. I'll stop there.
Thank you, Miriam. You touched upon some really interesting points, and we'll be discussing some of them throughout the panel, especially the point on the regulation of the use of AI in dispute resolution. So you've mentioned a lot of interesting points about the pillars of the dispute resolution system. So I'll get over to you, Joshua. So we know that arbitrator neutrality is one of the pillars of the whole arbitration system. So if we're thinking about predictive justice or the decision maker as an algorithm, what does this concept even mean? And will we have to rethink a bit the pillars of the arbitration system if we move towards this?
It's a great question. And thank you, Zad. Thank you, Umar, and the OICAC and Jasmundi for inviting me. I want to clarify, when we use the word AI, it's not a very precise term. And I think I just want to state that we're talking here about large language models, not machine learning tools more generally, and that distinction is going to matter. And then more specifically, we're talking about generative AI tools, meaning ones that are not purely responsive, but can generate content and make decisions on their own, however, only when prompted to do so. And that's that key point of oversight that Miriam emphasized. Now, when we talk about whether the use of AI tools in decision-making challenges fundamental principles of arbitration like neutrality, I think you have to break down the issues into sort of the legal ones and the in-practice ones. On the legal side, we have to think about consent. Arbitration is a consent-driven process. We have to think about enforceability of the results of awards. And then especially, I think we have to think about neutrality, which really crosses that line between the legal and the practical, since it's an important reason why parties might choose arbitration in the first place. Now, personally, I don't see a legal problem with parties consenting to entrust their dispute to an algorithmic decision maker. That already exists in so-called smart contracts, although that name is really misleading in a couple of ways. First, they're not really about dispute resolution. They're really a way of implementing a stipulated remedy, sort of a narrower use. But also, they're a relatively simple bit of code that will release money in escrow when certain events or conditions take place. So they aren't generative AI. Here we would be talking about something actually new. But I think the line has already been crossed in the sense that we accept by consent all kinds of supports for arbitrators, human, like a tribunal secretary or junior associate, and otherwise. Now, many statutes, many procedural rules require expressly or kind of written on the assumption that the decision maker is a human, which means that there will be enforceability concerns in some jurisdictions if the parties opt for a truly automated decision maker. But I think if parties can agree to arbitration without written reasons, or they can agree to arbitration on a baseball arbitration style, where the arbitrator simply chooses between two proposals without explaining their reasoning, we're already at the point that we've accepted that parties, whether human or legal persons, can choose something other than purely human reasoned application of legal rules to facts in order to reach a decision. I think that's a choice that parties are entitled to make, right? They might prefer the trade-off between cost and accuracy that might be represented by turning to AI tools for predictive uses or for decision making. There's a group in Canada called ADR Chambers. I know that name is also used in other places. This one it's a privately held company in Toronto that uses a large roster of arbitrators, and they've just started rolling out offering parties two different price points, depending on whether the arbitrators do or do not use a proprietary AI tool that they've developed in collaboration with a tech company. So these kinds of things already exist. The concern for me that I think people are underrating is neutrality. Because that's not just a matter of consent, and it's not just a matter of formalities to achieve enforceability. It's fundamental public policy. States will not allow parties to choose a biased arbitrator, right? That's why it's in Article 5 of the New York Convention as a ground for refusal of recognition or enforcement, or as a ground for setting aside if the arbitrators functionally have their mind closed to a party due to lack of independence or impartiality. And using algorithmic decision-making tools, I think a lot of people expect, well, it's a machine, it won't have human biases, it won't be bigoted, for example. It won't display cognitive illusions, the sort of twists in our way of thinking that are not purely logical. The thing is, though, people have biases, people have interests. That's why the standard is impartiality and independence. AI tools may not have interests, but the people who make them do. And the sort of black box nature of the programming in many large language models creates a serious risk that human biases will also affect the decision-making by the generative AI tool. I mean, companies that produce AI tools, the large language models, are constantly making tweaks to them. They have different personalities from version to version, and that's as a result of deliberate choices made by the programmers. Literally just yesterday, somebody leaked the full system prompt for ChatGPT 5.5, which is the kind of background prompt that's automatically added on to everything that users write into the prompt box. A lot of it is pretty boilerplate and expected and sensible, but one of the instructions forbids the model from talking about goblins, gremlins, raccoons, trolls, ogres, and pigeons. Why? Because they found that the AI model was referring to these things too often, because it's trained on human texts, including fairy tales and fantasy stories that feature goblins and gremlins. So AI has biases because it's programmed to, and AI also has biases because it's trained on human outputs. And we might not always like what we see in the mirror that AI reflects back at us. Witness all of the disputes over racial and gender matters coming out in AI tools, especially image generators. So I think we're going to see algorithmic decision-making in arbitration, and I think we're going to see challenges to awards based either on an argument that the financial interests of the vendor that created the AI tool programmed it in such a way that there are biases that come out in the outcome, or under a theory that the training data used for the AI tool itself introduced biases into its decision-making.
Thank you, Joshua. It's a great answer. And I think this is why we're starting to see more of a distinction between just the general term of bias and harmful bias, because bias is inherent to us as humans and to the algorithms that we create. But is this bias harmful or not? And this is the question that we're trying to see more and more today, with people understanding that bias is inherent with any generative AI tool that is trained on human data. So this is a really interesting question. And you touched upon an important point, which is consent and trust in the process. So maybe this will lead me to you, Riam. So we know that this is really one of also the pillars of the arbitration system. So in practice, do you think clients are at a stage today where they would trust an AI, a generative AI tool, to decide their disputes? And if not, where do you see the developments need to go to build that trust for clients? Or do you think it's basically we're a long way ahead to reach that point?
Thank you, Ziad, and thank Jusmundi and the OIC, Omar. Thank you very much for having this interesting webinar with the very esteemed panelists. So to answer your question, if I was the client, I would not. And generally, the answer would be not really. The clients would not trust AI to give them an award. Because even if an AI system is consistent and efficient, which are some of their benefits, but many parties would worry, why did it decide that way? There are bias embedded in training data, and there is the inability to challenge the reasoning behind an award in a meaningful way. And actually, trust in arbitration isn't about just getting the right answer or the right award. It's about legitimacy, feeling heard, believing the arbitrator understood your claim, accepting the outcome, even if you do lose sometimes. Having said that, I should mention that already some matters are resolved by AI arbitrator. To date, the only major institution that does that is the AI arbitrator of the American Arbitration Association, the ICDR, International Center for Dispute Resolution. A year ago in 2025, they introduced this tool, which evaluates claims, suggests outcomes, and does draft arbitral awards, but it's only tailored for construction document cases only. So there is no allowance of witnesses or of hearings. And coming to the second tier of your question about the limitations of AI, which I believe that they were tackled by Miriam as well, there are many aspects. First of all, like explaining the reasoning of awards. Arbitration does depend on reasoning, and with AI, that's not necessarily the case. And not only for clients is it a problem, but also for judges, it's a bit problematic because judges do expect to have the reasoning that they will scrutinize. And then we come to the assessing the credibility and the human communication aspect. And this relies heavily on who decides your case and who would you believe. AI is weak to evaluate witness demeanor. It has issues with interpreting cultural or linguistic differences. And here I refer to the behavioral scientist, Professor Albert Mehrabian, where he said that face-to-face communication is made up of three main elements: nonverbal behavior, tone of voice, and words. Having body language, which is the nonverbal behavior aspect, accounting for 55% of effective communication. And of course, with AI, that is not there. So AI doesn't really see the whole picture. Now we move into exercising discretion and not just applying the rules. Arbitrators don't just apply the law mechanically. They balance fairness, equity, and commercial reality. But to the contrary, AI performs best when the rules are clear, when the outcomes are predictable. So it doesn't really, it struggles when there are standards, they are vague, and when the context overrides strict rules. Now we move on to procedural fairness and legitimacy. And even if AI were accurate, which in some instances it's not, the parties might still reject its authority. Like they would say, was I actually heard? Could I challenge the decision maker? Who is accountable if this goes wrong? There is no accountability with AI. And also to mention that there is bias and training data risks. And it was mentioned before by the two panelists, the enforceability issue. And under the New York Convention, awards must come from a recognized arbitral process. There must be identifiable arbitrators. And like Joshua said, the arbitrator has to be human, and due process must be respected, whereas a fully autonomous AI arbitrator raises questions as who issued the award, whether you can challenge or not. And this leads us to the lack of accountability. With humans, there is accountability because we have our reputations, we can be challenged, we can be removed as arbitrators, and we could face liability or even institutional oversight. But the AI systems, they don't have any of that. And finally, the inability to handle truly novel disputes. Arbitration often deals with new industries, unique contractual structures, unprecedented fact patterns. AI tends to extrapolate from past patterns, and it struggles with genuinely novel legal questions. So how come an AI arbitrator would like resolve these new issues? You require creativity from human arbitrators. So, to say AI would work best where the disputes are repetitive, they are low value, they are rule-based, and they're data-rich, and it breaks down when they're high value, factually complex, and there are legitimacy and sensitive issues. I would want to refer to the guideline of the Silicon Valley Arbitration Mediation Center guidelines, because they developed guidelines in 2024 on the use of arbitration of AI, I'm sorry, of AI in arbitration. And I would refer to guideline 6, which actually tackles that, because it expressly says non-delegation of decision-making responsibilities. So this guideline underlines, and I'm actually reading from it, this guideline underlines the critical principle that an arbitrator's mandate, especially their ultimate decision-making function, is personal and non-delegable. This guideline doesn't prohibit or ban the use of AI tools by arbitrators to assist them in fulfilling their responsibility and duty to analyze the facts, arguments, evidence, and the law, and to issue a reasoned decision. While AI tools are capable of managing information, analyzing data, and predicting outcomes, they must not replace the human judgment, discretion, responsibility, accountability inherent in an arbitrator's role. Therefore, arbitrators must be mindful that they are not inadvertently delegating part of this personal mandate to the AI tool. There are two other paragraphs, but I would defer. I would suggest that the audience reads the Silicon Valley Arbitration Mediation Center, which are actually found on Jus Mundi Hub. It has all of the guidelines and others, which I'll refer to later. I hope this answers your question, Ziad.
Yes, that's great. Thank you, Herman, especially the last part, which is a natural transition to our second theme. But before I move on to the second theme, I would like to ask if any of our dear speakers has anything to add on the first topic of AI as the decision maker itself. So
I do actually, I want to pick up something that Graham said right at the end there about the personal nature of the arbitrator's mandate. I agree entirely. It's not something that can be delegated legally or should be delegable in a question of just professionalism and responsibility for the service, the product that arbitrators provide. But being prevented from delegating that task is different from being prevented from using any kinds of supports. Right? If we accept that a tribunal secretary, for example, can help draft an award, well, that's not somebody who has a personal mandate from the parties, even if they have agreed to pay for the hourly rate of the secretary's time. So I want to just draw the distinction between supports that must be disclosed, that must be consented to, but where responsibility ultimately remains with the arbitrator, and delegation of the arbitrator's function, which, as I said, can't be and shouldn't be permitted.
That leads me to directly our first question of the second theme, which I will direct to you, then Joshua, because you've just touched on this point. So, on this precise point of the support that the AI can provide to the arbitrator, there's a big distinction between, as you said, AI helping the arbitrator, for example, with procedural aspects of the case, managing the procedural timeline, or even legal research, and AI playing a role in actual decision making or the actual decision making process of the arbitrator. So, where do you draw that line of difference between both?
I guess I'd respond by saying I'm not picking on you because that's a very common way the question is presented, but I don't accept the premise of the question, that there is a line that can be drawn between different parts of the arbitral decision-making process. I mean, as I said, legally, I don't see a problem with arbitrators using supports, right? So long as there's disclosure and consent. But something being legal is not the same as it being ethical. It's not the same as it being responsible. Ethically, in terms of sort of ethical rules of professional obligations and responsibility, the obligation, there's three aspects to it. Only with informed consent, right, which requires prior disclosure, just as you would disclose that, as a tribunal chair, you intend to hire a secretary and get the parties' opinions on their consent to that. Avoid breaches of confidentiality or data privacy laws. And take responsibility for the final product. And I think as long as the arbitrator does those things, their ethical obligations in a formal sense are satisfied. But equally important is what you might call professionalism, right? Arbitrators should take responsibility for the powers conferred on them. They should feel the weight of their mandate, of what the parties have entrusted to them. And so this is where I have a problem with the line between sort of procedural or evidentiary support and decision-making. The most straightforward use case for AI tools in dispute resolution is to summarize fact evidence, to categorize it, to prepare chronologies, and so on. Now, the cost savings of using those kinds of tools are significant. I wouldn't want to downplay them, especially in factually complex cases with large numbers of documents, large numbers of witnesses. Parties have to pay for the arbitrator's time. And they have to pay for counsel's time, and they might rationally make a decision to save on time by using a variety of AI and other sort of mechanized or automated tools. But for me, I would say that working through the facts of a case, assembling a chronology of events in my own words, that's how I learn the case. That's how I come to understand what I think happened and to start to develop theories that I would want to test with witnesses or with further documentary evidence as it comes in. I don't think I could make good use of limited hearing time, let alone write an accurate award, if I had not gone through that process of learning the facts myself. So I don't think there is an area where you could say that AI tools are walled off from the decision-making process, because everything an arbitrator does to understand the facts or the substance or the law is part of the decision-making process. It informs the ultimate decision-making process. Now, as you can see, I'm not an AI doomer. None of this means that arbitrators can never use AI tools. But I think it's incumbent on anybody who uses a tool to learn how to avoid pitfalls in its use, to get consent to the parties after candid disclosure, and then, of course, to take responsibility for the final outcome, right? Not to succumb to the easy temptation of taking shortcuts, even when we know that it's a shortcut. I don't know how many times I've told law students, don't rely on the head note of a case report. That's a similar kind of thing, right? There, a human has prepared the summary rather than a mechanized tool, although that's changing with Westlaw and Lexis. But everyone knows if they've finished a university degree, relying on just the head note summarizing a case is risky. And there are the same kinds of risks on a much bigger scale when there's over-reliance on AI tools.
Thank you, Joshua. That's definitely a very interesting take on it. And I would say that I would tend to agree that the use of AI by an arbitrator throughout the whole process poses risks, even for quote-unquote more procedural aspects of that role. But you touched also upon an important point, which is disclosure. So I'll move to you, Miriam, and I would like to discuss a bit more this point of disclosure. So disclosure is, of course, a very important part of the use of AI by arbitrators. So we've seen a lot of different disclosure obligations from soft laws from institutions. So, for example, we have seen people say that arbitrators should disclose what system they're using, the prompts they put in, the outputs they receive from the AI. Some have more restrictive views, so the arbitrator should just disclose the use of AI in a general sense. How do you think arbitrators should disclose AI assistance in their work? For example, do you see it as modeled like disclosure of tribunal secretaries, or for you, should we think of a completely new model of disclosure for AI?
I need to unmute. Thank you, Ziad. I'm going to get to that, but let me just say something. If I heard Joshua correctly, I'm going to push back on something. There are legal problems with the use of AI in international arbitration or any alternative dispute resolution. There's 7 core legal zones, red hot zones, exposure zones, if you will. And you'll forgive me if I'm computer's slow, so I'm just using what I have on my phone on looking at email. Now, number 1 is due process. Okay, so that obviously can impact the enforceability of it, and challenging and malpractice. So we have key legal issues, and they all chime into due process. So, and this all comes to disclosure at some point, which should not be by each arbitral institution or arbitrary panel. I think it comes down to the bar, and I will say in the best sort of highline quotes I've sort of put in my head and written down for myself to always remember. I'll get to that. But look, we're looking at due process, breach of an arbitrator's personal mandate, the violations of the remedies as a result, confidentiality and data breach protections, which is a huge deal, of course, in the EU and UK GDPR considerations. In all arbitrations, there's an implied duty of confidentiality. So, and then with the American Bar Association, there's the same thing. And with the institutional rules, there's the same thing. So you can violate those confidentiality and data protections, not just at an arbitrator level, not just at an institutional level, but at a legal level of regulatory concern. 4, you have unauthorized practice and ethical violations by the use of AI in arbitration or dispute resolution. Evidence and procedural integrity problems. Okay, we have DeepSeek and the AI-generated evidence, right? So that's partly why we're all here talking about responsibility and ethical use of AI. But I need to make sure everyone understands, in my world, there is no such thing to say that there is no legal problem with the use of AI, even in the help and assistance of the process of arbitration, even in the efficiency. And of course, human oversight should be the case. But even before AI came into our world, and it's been around before anyone kind of got around to using it, there's human error. So there's a natural inclination by humans to, when we even have oversight, 1, we're humans, we err. 2, when we have subconsciously the idea that AI helps reformulate this, but I'm going to definitely read it and have the oversight, or my secretary did it and they used AI and they did. I'll get to the disclosure and what should rule that. They're human. And I'll have a subconscious thought, because I'm busy and everyone's busy, that I don't need to really get into the weeds and make the assumption that they may not have missed, or they may have missed something, or may not have gotten something right, or there was a mistake. So the evidence and procedural integrity problems, that leads to a variety of legal issues, enforceability, as I said, liability and insurance gaps, especially when you have third-party funding. You're going to have, I don't know how many provisions are going to come out in these third-party funding arrangements, and the insurance behind them as well, where if there's any failure to abide by AI regulations, legal or otherwise, or disclosures of the same, I mean, we're going to have levels of these kind of things, that you got funding can go out the window, and then it's recourse. It's not non-recourse, even if and your insurance could go out the window. And of course, we have practical problems with the institution. So I'm putting that aside. Let's just go to the question about how do we good Lord, how do we sort of bind across the board the use of AI in this manner. And I keep going back to, it has to consolidate. I mean, look at how many arbitral rules there are out there, arbitration institutions that are out there. It's mind-boggling. I've lost count. I don't count. It's exhausting. It's frustrating. They've all come out with third-party funding rules. That's changed. It keeps changing on us, okay? This is why I think that we have to stop looking at this, because when you think of it as what should dictate the disclosure of use of AI in arbitration, which again, I'm not a doomsday person, don't use it. I use it for its proper use and functionality with, above all else, ethics and responsibility in a responsible fashion. But you have to remember the fragmentation risk of this when you're trying to put the disclosure aspect. How do we disclose it? There's 100+ arbitral institutions. So if we each writes its own AI rules, it's chaotic. And a London-seated LCIA case, NY Council, Dubai party, Singapore tech vendor, whose AI rules govern? And how do we then say that same rule will govern the disclosure, or will it be the arbitrator, the arbitral institution, or will it be the people seated? You can't. This is why I come back down to the idea that the bar and our ethical rules are the things that safeguard justice. So that is why everything needs to default back to that, including disclosure. So where you are barred, this limits the disclosure, right? It's not gonna completely tighten it up, right? But it limits the chaos that can come from how do we have disclosure, in what way. It should come out of the bar rules to which we are bound. The American bar rules should come out with disclosures. That should apply across the board to institutions, I think. And American barred lawyers, even in any state, should always focus on the ABA and the IBA, because we know that IB is going to have something. But beyond that, we're just setting ourselves up for a cobweb you cannot get out of and unwind. And undoubtedly that leads to mistakes on disclosure and failure to disclose and disclosing wrong or untimely fashion, which snowballs into other problems of legal issues.
Thank you, Miriam. Before I move on to the third question, just checking if any one of the speakers would like to add something on disclosure or the legal issues.
Maybe I'll just clarify. I mean, I certainly don't think the use of AI tools is legally unproblematic. I just think that there's nothing inherently inconsistent with the principles of arbitration for arbitrators to use AI tools. But the disclosure issue is the core of it. And as Miriam pointed out, it's not simple. It's not just a matter of saying, oh, I used a Harvey, or I used a general purpose chatbot, or whatever it is. A lot more detailed disclosure is required, and that's true for arbitrators, but it may well also be true for counsel, for the reasons that Miriam was just mentioning, that factual changes or alterations to the factual record are a significant risk with AI tools. I think we're going to talk about counsel in a minute, so I'll leave it there.
Perfect. Thank you, Joshua. Yes, we're going to get to that point later for our third theme. And Miriam, you touched upon some interesting points, which I'll also leave for later. But for this point, I would just like to get to Riham to ask her a different question. So it's from a different perspective. So let's go by the idea that arbitrators will be using AI to process submissions, to assist with analysis, to summarize pleadings, etc. Do you think this will inherently change the way lawyers work, write, and structure their arguments? So are you heading towards a world where lawyers are drafting for an algorithm, so they'll have to be assisted by algorithms too in order to optimize the way they present their arguments? Do you see that inherently changing the profession and advocacy in general?
So basically, yes, because we're not only making these submissions to be read by the arbitrator, because in most cases arbitrators use AI tools, so there are dual readers, the human arbitrator and the AI tool. So we would tailor it would be recommendable that we as counsel tailor our submissions in a way to make them readable by both. And here we have to remember that AI determines what gets surfaced, what gets emphasized, and what is remembered from the submissions that we make. And that would require proper structuring of our memorials and submissions. And there are like a few suggestions for that. That we as council have at the back of our head, that our submissions would be summarized and paraphrased and simplified, so that we would have them being capable of being summarized in a clear and comprehensible manner. And this would require the repetition of key points, and that each section has a clear takeaway. And then, as much as we could, we should avoid ambiguity, and we have to be explicit and clear about what we're arguing and what we're claiming. Otherwise, AI would have a tendency to resolve ambiguity prematurely and to choose the most statistically likely interpretation. I think we should also be very clear, very neutral, and have well-supported prepositions in our language tone, because that would be more persuasive, and we should avoid having overly aggressive submissions. As council, we should be more selective and more curated in our arguments, have fewer arguments but sharper ones, and clearer prioritization of what we really want. Try to avoid, I know that this is always said, but in reality it doesn't really happen. Try to avoid voluminous arguments and extensive submissions, because with AI everything can be surfaced, but not everything gets equal weight. So actually, the structure of the submission is extremely important, and we should have clear issue statements, proper sectioning, and direct conclusions upfront, and have highly extractable narratives for the AI, because they're sensitive to headings, hierarchy, and repetition of key propositions. Frame our arguments clearly and expressly, and ensure that whatever evidence we present is presented in a proper structure, so we could have the documents tagged and categorize the evidence. We could present the chronology in standardized formats, link claims to exhibits, which we actually do, but it's just in a way to allow for the algorithmic digestion. And now, we as lawyers, we may and may not consciously be drafting for an algorithm. We are actually, but sometimes we don't realize it. And the 2025 International Arbitration Survey by White and Case and Queen Mary University of London found that the principal current uses of AI in arbitration include factual and legal research, data analytics, and document review. A majority of the respondents indicated that they expect to use AI for drafting correspondence, and that was 75% of the respondents, whereas for drafting submissions, that were 66% within the coming 5 years. The danger isn't that lawyers consciously write for algorithms, it's that we may internalize what the systems reward. And I think to end on that, I think if we aim to be good arbitration lawyers in the arbitration cases that we do, we should do both. We should write in a way that is comprehensible for algorithmic compression, and still tell a compelling human story. And this way we serve the dual readers.
Thank you, Ramesh. I think this is the risk of moving more into a mathematical way of presenting legal arguments, which may not always be the most suitable way of presenting it, especially seeing all the interpretation aspects that are always inherent to legal analysis. So we move on to our third theme, which is the use of AI by lawyers and counsel. So Miriam, I'll start directly with you because you mentioned some really interesting points in your last answer about the regulation of AI disclosure, but I'll ask about that more generally. So you said especially that you think it's the bar where the lawyer is that should regulate that use. But I was thinking in the context of international arbitration, for example, where you may have parties from different jurisdictions and the arbitration seated in a third jurisdiction, do you think this model still works, or do we need to move towards a more harmonized system, for example, by the International Bar Association that regulates in a more international manner for international disputes?
You did it again. I'll be brief as we're running out of time here. I think that in order to harmonize, yeah, it will be hard to do all the bars. So I think it's important to harmonize it into something that governs when we're talking about international arbitration. Let's see if the IBA does that. But also, one of the more practical steps of harmonizing, as we've been talking through this, is if we harmonize based on the bar or a bar or our ethical bar rules, and let's say the IBA has to harmonize that, we disclose that we are going to use as counsel, for instance, or even arbitrators or secretary, that we're going to use AI for help. I think that perhaps, and this is what I believe, you can, based on the harmonization of that through the IBA, trying to bring in all the bars, look, if it's done in an ethical manner and the IBA were the one harmonizing, there should never be a contradiction amongst the bars. It's very rare to find that. If you're doing it right and using it right and your purpose and your intention is right, there should not be a problem harmonizing it with the IBA. If there is, the lawyers, it's up to them to speak up and mention that issue and that's the disclosure. And disclosure, I think, can help to be harmonized about what that is and to ensure that it's not overused and nuances are not overused by lawyers, using AI, that is, where there's some real nuance and facts, is that you can also agree the kind of overarching type use or questions or formatting of the question to a generative AI platform machine. And I'll stop there because there's just so much to say about it. We're running out of time, but it's simply, I will say this: where we are now is not sustainable. And part of that is not to do with where are we with lawyers, what do we do as lawyers with arbitrators, it's that AI is moving way faster and progressing way faster than we are able to turn around and take a step back. By the time it's tomorrow, there's 3 new different kinds and then new tools. We can't keep up. So that's the key problem. And if anything, that's what should worry us, and we should try to figure out how to control that within our profession. Stop there.
That's a completely very valid point, because we have seen already guidelines that are maybe 2 years old and that have become already obsolete. So that's definitely something that should keep in mind. So I'm mindful of the time, so I'm going to be a bit briefer, maybe restrict the questions a bit to a more limited way. So Joshua, to you, seeing this, do you think in the context of international arbitrators, arbitrators themselves should have the power to sanction counsel for irresponsible or unethical use of AI, for example, if counsel submit hallucinated case law, for example? Do you think it's the arbitrators that should have the power to sanction?
I'm not saying that should be the only place of regulation. As Marian mentioned, some degree of harmonization is essential if we're going to have any kind of predictability and consistent use. So I think you have to be able to have harmonized rules at some point, but those rules will of necessity be general. The technology is constantly changing. The variety of different scenarios in which AI can be used in either negligent or deliberately deceptive ways is, infinite. And so I think the only practical answer to your question is arbitrators have to have some ability to police the use of AI tools and to sanction when it goes out of bounds. Now, that's largely a matter of getting ahead of the issue, right? Raising the use of AI, embedding kind of rules of the road for the particular proceedings into a procedural order 1, right, to the level of ensuring that cybersecurity concerns, that data protection laws are observed, but also for reliability, perhaps agreeing on a set of prompts to be used and that no other prompts will be used. Perhaps agreeing on specific AI tools that will be employed and others being prohibited, so that at least you have some known unknowns about what the biases of the tools being used are. It's mostly a matter, as is so much in kind of the craft of arbitrating as opposed to the law of it, It's a matter of anticipating problems, getting ahead of them, raising them with the parties, and then setting down in a procedural order what will and won't be acceptable. But I think sanctions have to be part of the arbitrator's toolkit. They have to be part of the regulatory solution. It could just be cost consequences. If sloppy or negligent or just unthinking use of AI tools ends up creating more work for everyone to double check transcripts and summaries and go back over parts of the proceedings that they thought were finished, cost consequences should follow. But I think also the arbitration community really has not come to grips with the more pernicious risk, the bigger risk of straight up faked evidence, of deep fake images, of summaries that are either deliberately or negligently used to skew the factual record and to change the basis on which a decision is reached. And if that kind of conduct is observed, right, is demonstrated in an arbitral proceeding, I think there have to be consequences. Now, I personally believe arbitrators have an inherent power to sanction counsel, but I know that's a controversial point, and I don't think you need to accept it, because you can issue a sanction to a party with explicit instructions to the party, you are receiving this sanction because of choices that your counsel made, and then the two of them can sort it out afterward.
Yes, I think the inherent power of arbitrators to sanction counsel will be something that will be discussed a lot in the next years, especially with this need of regulating in a day-by-day basis the use of AI. So you touched upon a very important point, and this is going to be my last question to you, Riham, on evidence. So we're hearing a lot about the use of AI in the context of evidence, so reviewing evidence, summarizing, or even generating evidence-related materials. In your opinion, have you seen any risks of this use in your practice, and do you think the current framework is equipped to handle this?
I will try to be as short as possible because I know that we will be opening up for Q&As. So basically, the known risks would be that you cannot trace with AI the methodology or the source or the data set in terms of evidence. And as mentioned before, there are reported hallucinations and fabrications of evidence, including deep fakes. There are issues with confidentiality and privacy risks. And there's always the risk of cybersecurity breaches, of course, and there are reported cases on that. Privilege and discoverability complications as well. In terms of the framework, there, like was mentioned, there are so many guidelines, and they are all not binding or obligatory. And like Miriam did suggest, it would be best to have a harmonized one, as also was confirmed by Joshua. And the CIARB's 2025 guidelines on the use of AI in arbitration, they do have a structured institutional guidelines on the use of AI, as well as the Silicon Valley ones that I had mentioned before. So I think harmonizing with one source that we all as lawyers and arbitrators would refer to would be the best recommendation. Thank you, Ziad.
Thank you, Riham. So that brings us to the end of the panel. Before we open the door for Q&A, just checking if any of our speakers has any final comments.
I'd like
think
to hear
for
from the
me-
audience.
It's been great so far, a lot.
Yeah, we would love to hear from the audience. So if anyone has questions, please send them through the Q&A. I already see one, but I think it's a remark more than a question from Mohammed, who says, I believe there's misunderstanding here regarding professional use of AI and non-professional use of AI. AI limitation is just a tool that has to be used professionally to reach the right outcome. If anyone uses it in a mediocre way, then it's their own liability. And for professional use of AI, it would reach 80% of good results. Coupled with human judgment, it could reach 90 to 100% in the opinion of Mohammed, who sent the remark. Miriam, would you like to comment? I see.
I don't know. Well, first of all, I agree that there is a limitation in the use of it professionally in this sense. there's limitation in any use of it professionally, but particularly when you're dealing with high stakes or lives or justice, trying to get to truths, facts, factual matrix, and then causation, which, by the way, very hard, very, very hard to think that AI is going to give you, no matter what we have to teach AI to be smart. Like I've said in my article, it's neither artificial nor is it intelligent. It is us, the humans, who create the AI model to be intelligent for us in what we need. So it's hard to figure out how one can possibly teach, like, for example, causation. So the comment Mohammed states is right. I think I agree that there is a misunderstanding regarding the professional use and non-professional use, and there are limits to the professional. I don't know, and this is me saying purely, I don't know how we can reach these percentages of good results versus not, because even in the best of circumstances, in the most transparent of ways, in arbitrators just 2 years ago, where AI was not even touched or anything, a year ago even in the best of circumstances, I would argue that their decisions are rarely, if ever, somewhere between 90 to 100% good, right? Or that their analysis or reasoning was good and their final conclusions were right. So it's very hard to put percentages on that. But the premise is correct. There's a distinction, and there's a way in which it's to be used, both in non-professional and professional ways, that make it helpful to be right, to come out with the best use for an outcome, not the best outcome. And that's it. I can't put a percentage on it.
Thank you, Miriam. We have another question, but before we move to that, any other comments on the first remark?
Well, I'd say in a large extent, my answer to the first question leads directly into the second, which is, I mean, I agree entirely with the premise of Mohammed's question that there's professional and unprofessional uses of AI, and that the obligation of the profession is to learn to distinguish between the two and to take responsibility for our use of AI tools as we take responsibility for use of other tools. And that, I would say, is the single biggest thing, and this is to shift to Professor Onyema's question. The single biggest thing that can be done by universities, by other legal training institutions, is to teach AI use as a tool, right? Not as a replacement for human judgment, but as something that can be used, like any technology, to do the things we were already doing faster and cheaper, and to enable individuals to do more than they otherwise could with our sort of, limited flesh and blood bodies and brains. So law schools, I think, cannot hide from AI. I think it's an obligation now of law schools to help prepare students for use of AI tools in their practice. That's something that is now embedded in my university's required legal research and writing course for first-year students, and in a lot of other coursework as well. In my first-year contracts class, I take a legal concept we've already discussed in class and ask students to prompt an AI tool to explain that concept under Canadian law, and then to critique the answer. Now, this is not training them to be experts in the use of tools, that the technology changes so quickly that expertise would be stale by the time they graduate anyway, probably stale by the next summer. But what it does do is it starts them thinking of AI tools as a source of information and a source of assistance, but one that has its own limitations, and that you have to learn how to avoid its pitfalls and take advantage of its benefits. But either way, you still have to take responsibility for the final product yourself.
Thank you, Joshua. So that answered a bit of Professor Onyema's question. Miriam or Riham, do you want to add anything on that point?
Not really. I would just say yes, that they should be having a course during the law school years just on AI usage.
I would tend to agree. Of course, my experience is much more limited than Professor Carton, but from my teaching experience also, I have noticed the real importance of not only teaching students how to use AI tools, but really emphasizing the ethical and responsible use of AI and making them really understand the risks that they're going to face later on as practitioners. I think it's something indispensable because AI is definitely here to stay.
Can I just say on this, though, that you have to recognize that the people that are supposed to be teaching this have to be so well versed, so up to speed and ahead, okay? Even ahead, anticipating the changes of AI and its usage and all of the various tools within AI itself, which is just mind-boggling how fast it's happening. Those are far and few between. There are not many out there. And I actually, if anything, you'll see people who have little to no technological experience, which I consider myself one of those people, but I'm not sure I'd even invest the time to try to figure this out. But they're the ones who are going to sit there and really figure out all these different AI platforms and the rankings. You know, Claude is great for this, and I don't know, My Face or MA, I don't know what it's called, is great for that, and Thomas Reuters, whatever that thing is good for I mean, who do you get to teach it in a legal framework, or let's just say fully, how do you use AI in an intelligent, responsible, and ethical manner in any profession, in the basics, when it's going like this, and there are very few in the first place to understand it. I don't have an
Can I
answer.
just say, I mean, law, of course, does not change at the speed of technology changing, not the same pace. But law schools, university law faculties have always dealt with the problem that the particular, code provisions or leading cases or whatever that students learn as students are not going to continue to be the same throughout their career. The law is always changing, even if more at a generational pace. And so I think university law faculties have always taken the position that it's their duty and their role to teach the fundamental skills, how to think through the use of rules, for example, the relationships of cases to codified statutory law. And if students are equipped with those sets of skills, they can cope with the changes in the law as that occurs during their careers. And I would say the same for AI. What matters is teaching the use of fundamental understanding of the role of AI tools, their advantages and their limitations, how best to use them, and how to use them in a manner that satisfies both kind of professionalism in the casual colloquial sense and also ethical professionalism in the rule-based sense, obligation to clients, obligation to the courts, and so on. And I think if universities focus on those kinds of the equivalent of fundamental legal principles for skills, their students will have the tools to continue to thrive as the technology shifts. Now, that does not reduce the burden on educators to themselves be educated enough. And that's a great point that Miriam made, that so many legal academics do not have the knowledge or don't have the confidence to teach these kinds of skills effectively. That's a problem. But I think the response is the same response that universities have always had, which is to hire new generations of scholars who have that expertise, and to rely on adjunct professors and instructors from practice, from industry, that have the kinds of expertise that aren't within sort of the core permanent faculty members.
Thank you very much, Joshua. So I do not see any more questions in the Q&A chat. So we just got a last question. From
Ziad, there was a question on the use of umpire-assisted AI models. I don't know whether you saw that.
Yes. So Faraz says, I think it will make better to have umpire-assisted AI models than tools assisting arbitrators.
I think this is the point Miriam and I were discussing before. It might be legally permissible, but I don't think it's a good idea.
Yeah. Yeah. I mean, here we are, we're adding another layer, and then there's gonna be another layer, and there's gonna be another layer. And the whole goal is to ensure simplicity. By the way, when we say it's not simple, we can make things as simple or as complex as we want them to be in a variety of different contexts. I won't get into a few things, but a lot of people have heard, oh, it's complex. Often that is an answer we all often default to when we're afraid of actually saying the real answer or the real truth or trying to get to it, or that we just simply cannot. And yes, it's complex, or maybe we just don't know, and that's the answer. Because saying it's complicated is not the same as I don't know. So here we are with the layers, and I agree. I don't think it's a good idea for an umpire. I appreciate the innovation, and I should say this about it. And I want to say this too. This is very important. There's a really weird sense of innovation. You know, that's the thing. We're all just striving for this innovation. And innovation can also be the biggest enemy. It's sort of like you create a monster out of your own innovation. That is very much what's happened with social media, but it's serving its purpose. And within 5 years, you can predict social media will no longer be social media. And artificial intelligence is not a social media tool. It's a separate kind of thing, and it may be a thing that runs the show. And so this idea of innovation, and running after innovation could be the very demise of the things we're trying to do and fix and make better and all that. And institutions, bars, arbitral tribunals, teachers, universities, all of them are trying to keep up with the innovation. Great, that's fine. Let's do that. But let's ensure that innovation is never outrun, is never outrun by integrity. At the very end, it's win or lose, an award in arbitration has to be enforceable, and enforceability rests on one thing: the world's belief that the lawyers running the arbitration, listening to it in the room, behave ethically and responsibly. And how that plays out, we don't know. So I just wanted to bring the innovation point, because everyone thinks it's some sort of like, I don't want innovation. No, we love innovation, but not at the expense of everything else, especially in this space.
Thank you, Miriam. So we have 2 other questions in the chat. So first question from Ismail Habib. Does an AI legal framework need to be established regarding court submissions, proceedings, and judgments, or justice written with the assistance of AI? I have a proposition here. A lawyer may draft pleadings through AI-generated tools, and a judge may use AI to write a judgment. What would the respective panelists say on this issue?
I think there is no problem in using AI to aid with the drafting of the pleadings, so long as you do review everything that has been written thoroughly. Whereas we did discuss the matter of having awards drafted by AI arbitrators, and I, for one, would not advocate for that. That the awards be drafted by AI.
Miriam or Joshua, do you have something to add? Because we still have another question in the chat. So we have...
I agree with Ram.
Yes.
Yeah, I agree.
So I think it's the final question we have from Rafiq Tiryaki. He says, which do you think is more consistent with the essence of arbitration? A procedure and an award that satisfies parties' expectation with no disclosure obligations, or a procedure and an award in which AI disclosure obligations have been violated but satisfies the parties, and which is more realistic for tribunals to disclose but not satisfy parties, or to not disclose but satisfy the parties?
I don't think I accept the distinction that the question makes. Even if an outcome is in my favor, if I later discover that the only reason that I won is that a human arbitrator was biased against the other party, well, that's an inherently illegitimate process, right? That the party's expectations were satisfied on false pretenses. So I don't think you can distinguish the outcome from the process. Arbitration, obviously, it's about the outcomes, but only if they're reached, through consent. But that consent has to be informed. And just as a doctor couldn't say, well, you didn't consent to the surgery, but look, I took out the tumor. You still need informed consent as a physician before you cut into someone's body. And I would say the same with arbitration. Otherwise, it's not truly satisfying the party's expectations.
I guess this is why we have disclosure obligations in the first place, is to satisfy both parties' expectation, because both parties have different expectations for both the outcome and the proceeding.
And that leaves aside the fact that arbitration doesn't exist in a vacuum and depends on national court systems to enforce decisions. And they're not going to accept, and they shouldn't accept, results that were arrived at, through subterfuge, through undisclosed interests and biases.
And transparency is always important in that context.
Of course, it's one of the essence too of the process. So I see no more questions in the chat, so I think we can top it off at there. Before we close, I would like to ask our speakers if anyone has some final thoughts before we end this webinar.
Nothing from me. I think we've covered a lot. Thank you. It's been a pleasure.
So I
The
think
same for me.
Yeah.
Thank you, everyone.
Same here. Thank you, Ziad, and thank you, everyone.
Thank you.
Thank you. So in the name of Yusmundi and OIC, I would like to thank you once again for accepting our invitation and for this great panel with many thought-provoking aspects. I'm sure all our attendees will leave this webinar with a lot of issues to think about and to research and to read about more. So thank you once again. Thank you to our attendees for staying with us until the end and for all the questions that we submitted. It was great hearing your opinions and views about this very fascinating topic. And Dr. Umar, if you have any final words before we conclude, I will leave it to you.
Well, thank you very much. It's a very interesting topic, and I'm really glad we had all of you today. And thank you for sharing your views. It's always a very hot topic whenever you discuss anything AI or even technology. And of course, technology keeps evolving. So even as we're actually kind of concluding the session, I can see more questions are coming in. Basically, I don't know whether we're gonna, answer those questions because we're already concluding the session. But again, I will also let me pass the ball back to you, Ziad, because you're the boss here. If you want to decide to take those two questions before we go, I think it's up to you.
I think in view of the time, I think that the questions have been widely discussed, the ethical responsibility to disclose. I think we have discussed that in length. So in view of the time, we're already a bit late. I'm sure we all have a full schedule ahead of our day. So I would propose to cap it off here.
Excellent. Thank you very much, everybody. And of course, I'm going to thank all the participants for joining us today. We'll be having the next webinar, I think, middle of May. My team has just informed me that, and it's going to be on a special award. It's a case study on an ICC award and relating to a thermal kind of dispute somewhere. I think the guy who handled the dispute will be coming live. So they're going to have a fireside chat for that webinar. So look out for that. I think we'll be having that on our LinkedIn page later, maybe tomorrow or later in the week. And once again, thank you very much, panelists. And I look forward to catching up with you again soon. And of course, the summary of the webinar will be provided by my team. They also have the video of the webinar on the YouTube page of the OIC Arbitration Center. So for those who like to watch the webinar again and learn from our learned panelists, they do have that opportunity to do that, later. Thank you very much, and enjoy the rest of your day. Bye-bye.
Thank you. Thank you, everyone.
Thank you.
Thank you.
Bye.